The National Brotherhood of Fathers' Rights welcomes you to an enlightening presentation for fathers in trying situations. Join us for a private audience discussion with Mr. Dennis Gack, founder of the National Brotherhood of Fathers' Rights, and questions by Mike Hill, an NBFR associate. On this audio companion CD, Dennis will give you insights into a wide variety of fathers' rights cases. Mr. Gack has authored the 9 books in the complete Father's Rights Protection System that you've received. He has an extensive legal background with 20-plus years in family law and specifically in fathers' rights cases. He's a source of knowledge that even practicing attorneys turn to for insight and valuable information. This audio companion CD provides legal information, and our information is not to take the place of individual legal advice as obtained by an attorney. This CD is a fast-track primer, giving you a quick review of many common fathers' rights issues. Let's listen in now.
Next area that comes to mind is contempt of court hearings. Contempt, the word contempt, C-O-N-T-E-M-P-T, means, in legal terms, a willful violation of a court order. That means there's a court order in place and that you purposely, willfully, with forethought, violated the order. What happens in most cases when contempt's filed against the guy, it's usually for child support. Rarely does a woman ever file child support or file a contempt proceeding against the guy for not seeing his kids. It seems to never happen. But they file contempt against non-payment of child support. Not paying child support does not necessarily equal contempt. A complete defense is a non-willful violation of a court order. If you're laid off from work, if you don't have an income, you can't pay child support. So when you answer contempt, you write up a declaration that basically states, I haven't willfully violated the court order. I couldn't pay because I could not pay. I don't have the ability to pay. This is key. Contempt is supposed to be a remedial process, not a punitive process. Remedial meaning to teach you something. Punitive meaning to punish. Unfortunately, most of our court system, either forgets this or something, but they basically equate non-payment to contempt, and it's almost as if they're trying to punish you because immediately jail comes up. Most guys do not go to jail for contempt. If you respond properly and you make certain arguments, and if you're certain arguments like your non-payment is not willful, and you attempt to pay something towards, I don't care if you owe $500 a month, flip her a $10 bill, flip her $25, whatever, pay something in a consistent pattern. Technically speaking, you're making an attempt to pay. There isn't a willful violation, therefore there isn't contempt. Hopefully the judge agrees with that argument, but that's the best possible argument you can make in that position. Now, Mike, you and I know we both get calls from guys every day on the phone. They call up and they say, well, I got a contempt proceeding coming up next month. Can you guys help? And we ask a few questions, and we find out the guy hasn't paid in 5 years. And we ask, well, have you paid anything in 5 years? No, nothing. Well, that is contempt by definition. You had to have made some sort of effort to pay. It's not reasonable for anybody to believe that in 5 years you couldn't have paid $1. It's not reasonable. There's contempt.
Dennis, does he have to prove that he's paid? I mean, maybe he only paid $10 or $15 or $20.
Yes.
Does he need to have a receipt?
Yeah, he's got to prove that he's paid. And this is another bugaboo that guys get stuck with all the time. They pay mom in cash, they don't get receipts, or they lose the cash receipts. If you pay in cash and you don't get a receipt and don't save the receipt, you're screwed. Okay? Most often, the judge will not believe you. So it's important to get receipts. One way to make sure that everything's receipted is to pay through the state. I know guys don't like having their wages garnished and such, but at least you've got a documented record, a computer printout of what your payment record has been, and you don't have to search through shoe boxes to find out whether you paid mom $50 in the parking lot while you're dropping off Junior. So it's important to have receipts.
Well, along the same lines, what happens if I am paying for daycare? And how do I know that the kids are really going to a certified daycare center? Do I get a receipt from mother?
No, typically not. And this is where it's important. I've stressed before that you need a very accurately written order. An order will typically say, Dad pays so much to Mom. Mom can do whatever she wants with that money. And mom will go to court saying, I need money for child support, and I need money for daycare, and I need money for special education or whatever. The judge will usually lump it all together, make one order. The order is written very vaguely. Dad pays $800 a month to mom, and $200 was supposed to be for daycare, $100 for extra tutoring, and the rest for child support. If it's undifferentiated, if that order isn't clearly defined, so much for this, so much for daycare, so much for special education, you'll find that mom can spend that on whatever she wants. And what often happens is it was originally used for daycare. Now Junior's not 4 years old anymore. He's 14. Dad's still paying for daycare that she hasn't used in 7 years. It sounds funny, but I deal with cases like that all the time. If she's not using daycare and you suspect she's not using daycare, take her to court on a modification right away. Get that order clearly written, everything broken out, demonstrate that she's not using it, or the child's way too old to be using daycare, and get it changed right away. If you don't change it, you pay. If you don't bring up an action in court, you pay every time. A mom's going to get the benefit of the doubt. Non-payment of support, as I mentioned, is an all too common occurrence in contempt. However, there are other contempt proceedings. Let's talk about the flip side of it. Mom denies you visitation access. This is an enforcement proceeding for you. Not only can she use it against you for non-payment of support, but if she denies you access to your kids, you must do something to enforce your rights, guys. There's a rule in law, I call it, if you don't use it, you lose it rule. In other words, if you don't enforce your rights, you lose them. Even if you have a clearly written court order, and she's clearly supposed to do certain things at certain times, if you don't take her to court when she violates it, the court's going to wonder why you waited 2 years all of a sudden to come into court and then access your rights to the kids. It's important you file a contempt of court proceeding against her. Certain kind of do's and don'ts in a contempt hearing or any type of a hearing, particularly with domestic violence, contempt. Come to court with a properly written response arguing that your noncompliance wasn't willful, or demonstrating through third-party proofs that mom denied you access for the kids. The opposite is true. You have to prove that mom willfully, purposely denied you access to the kids, and third-party endorsements is really important. Come to court with complete payment records and receipts. Mike, that goes back to what you're talking about. You've got to have proof. Come into court with a payment plan. If you owe back support, child support arrearages we call them, come into court with a proposed parenting plan. If you don't, they'll come up with a plan for you and you won't like it. Trust me. Make the judge aware that you are in the process of filing a child support modification. In other words, you're coming into court, you're saying, hey, I haven't willfully violated the court order. I know that I'm behind in child support. Here's my proposed payment plan. And by the way, Judge, I'm filing a child support modification at the same time to try to get my basic support lowered. Be humble at the hearing. You're in their playing field. You're playing their game. Don't get angry. Don't get emotional. Put everything in writing. Have a payment plan, like I said. Also, walk in the court and have maybe a payment with you. Walk in with a couple $100. If you do these sorts of things, you'll find that you probably will not be found in contempt. You're certainly not going to go to jail. And by the way, guys, you got this jail scare. Generally speaking, the judge, even if he finds you in contempt, will not put you in jail immediately. Yes, he can. But typically they give you a chance to what's called purge the contempt, which means they give you an opportunity to come up with payment. So you go to court day one, they find you in contempt. They usually give you 30 days or 2 weeks or something to come up with so much money or to demonstrate. If you come up with anything even close to what they're asking for, or even half of what, it shows an attitude of compliance. They're typically not going to throw you in the can. So that goes back to what I said before about a remedial process. They're trying to teach you or educate you to pay rather than punish you. If you know that about the system, you won't be so afraid of going to jail for contempt.
Dennis, I have one other question. What if I'm paying child support for 2 children and one of those children is working? Do I still have to pay the same amount of child support?
Yes, you have a court order. You must comply with that court order no matter what happens to anybody unless you modify. If there's some kind of a problem that you have, why you think you shouldn't pay, or if you're paying too much, you have to go to court. You have to file a modification process and change the orders. Otherwise, the orders apply. I don't care if there's a daycare order in effect and your kid's now 18 and he's going in the military. Do you have to pay the daycare order? Yes, until you modify the order. Sounds ridiculous, but that's the way the rules are.
Again, that's good to know.